Manever I say ma PENDREAM TV. PENDREAM TV there osia dem yopo.
So the Supreme Court today handled two important things. One, a review application by the Attorney General with respect to decision as far as the Boahene case is concerned, and also an appeal ruling on the NAM1 case. Before we get to that of Boahene, I must say that NAM1 came to the Supreme Court appealing the decision of the High Court, asking him to open his case, and the decision of the Court of Appeal affirming that same decision. The Supreme Court has quashed his application seeking to review or reverse the decision of the High Court and that of the Court of Appeal. We have with us Frederick Forsen, a long-time spokesperson for the aggrieved customers of Menzgold. Today, when you were coming to court, what essentially was your hope, and will you say that that has been met?
Yeah, for us, right from day one, we believe the Attorney General had a good case, and so after the prima facie case was determined, we were very positive that the trial was going to go on smoothly. However, when the prima facie case was determined, NAM1 challenged the ruling of the court at the Court of Appeal, and that was refused. And satisfied with the ruling from the Court of Appeal, he went further to the Supreme Court here. And we've been here for the past almost 1 year, and today the law lords have refused his application because he sought the court to give him a special leave so that they will halt the trial at the High Court. But today the court said no. And so what it means, our understanding is that the trial at the High Court can continue. And so today we also told that they will file their reasons on the 17th of this month. We shall go back to the High Court as was determined the last time on the 16th of this month, which is next week. So we are very happy and we appreciate what the court has done, just that it has kept long.
Do you get the sense that his appeal on the decision of the Court of Appeal has been decided upon, or is just an application to stay proceedings as matters go on at the Supreme Court that has been decided?
From our understanding, I think he filed two applications. One of them was the former appeal. I think what he brought here was that he wanted the court to stay pending appeal, and the High Court refused it. Then he went to the Court of Appeal, and the Court of Appeal also refused it. In fact, at the last one of the settings, even at the Supreme Court, the court said he should go back and continue with the trial whilst they come up with their ruling. And so this is about the third time we have had two previous adjournments, and so this is the final day that the court has formally refused his application, meaning that the trial at the High Court can go ahead.
So what you understand is that it as the trial will go on at the High Court. Do you also get the understanding that you also have to come here again for the substantive appeal?
I'm not sure. Per the ruling today, it means it's over here, except maybe he want to take another decision. That is up to him and his lawyers. But for us and for our understanding, what happened here means that the trial court now can go ahead with the case.
It's been
so he can open his defense, because at the last sitting the judge directed him that when we go on the 16th, he should be prepared to mount the witness box and open his defense.
It's been how many years now? Since 2018.
I'm telling you.
How has your membership been like, and what has been the ordeal of a number of people whose monies were locked up with Menzgold?
We have gone through a lot, Hanson. It's almost 8 years now, 7 years. I have spent 7 productive years of my lifetime fighting this cause as the leader and the convener of this group. And we have buried more than 244 members. And on the issue of the situation, the condition of our customers, we are even tired of discussing them. Debt, harassment, adversity, poverty, broken homes, shattered dreams, destroyed businesses, and the rest of them. So it's not been easy. All that we are looking up to is that the trial should speed up. I remember when we started, before the prima facie case was determined, we were almost going on a daily basis. And so we pray the courts that now that the Supreme Court has given the go-ahead, we should resume that daily trial, so that at least we can come to some finality. Because even this, the case moved to the High Court in 2023. And here we are in 2025, the year is almost dying. So we would pray, we want to use these platforms to pray that the court will resume that daily trial, so that we shall have some finality and conclusions to this matter, because people are really suffering.
I know you've also been pushing on the side of government to come to your aid with respect to what they usually do for the banks, to at least come and pay the investors whose money have been locked up in Menzgold. How far have your negotiations with government gone?
Yes, the last time in July, there was a meeting chaired by His Excellency the President himself, and we have also met the Attorney General. Now, what is at stake is we are waiting for the appointment of a receiver, and when that one is done, at least it will make the assurance double sure that government is committed. Whilst at that, we have also appealed to the government to consider sort of a bailout for us while the trial is going on. So we are looking forward for some of these things. Today I just had a short chat with the Deputy Attorney General, and we expect to go further with other discussions to see how quickly the receiver will be appointed, because that will mark the official acceptance or acknowledgement of the government of the issues involved in the Menzgold customers.
So when next are you to go to the High Court?
On the 16th of December, which is next week, we are going back to the High Court at 9:30 a.m.
So thank you very much. That is Frederick Forsen. He is spokesperson for the Menzgold customers. He says that the ruling from the Supreme Court today paves the way for trial to continue at the High Court, where Nana Mensah, also known as NAM1, is expected to open his defense. The case relates to an order by the Securities and Exchange Commission in 2018 to order a closure of Menzgold Ghana Limited. A number of customers who had deposited money with Menzgold Ghana Limited in the form of purchasing gold from a sister company of Menzgold Ghana Limited had their thousands of Ghana cedis in investments locked up, and from 2018 till date, most of them have not been able to retrieve their investments. There have been a series of protests and petitions, and they've also followed keenly with a criminal trial, hoping that at least some justice will be done to them, and they are asking the government to come in their aid to appoint a receivership for Menzgold Ghana Limited, so that at the end of the day they can be paid their dividends, as they describe it, as well as their investments that have been locked up in Menzgold Ghana Limited. Now, as part from the issue relating to Nana Mensah, there was the case with respect to Boahene, the former boss of the National Signals Bureau. If you would remember, Boahene, together with his wife, have been on trial for alleged acts of causing financial loss to the state, stealing and using public office for profit, as well as money laundering. The case has been ongoing at the High Court, where they are still within the case management conference process, where the state is disclosing to the accused persons documents and potential evidence that will be relied upon in prosecuting the matter. At the High Court, the lawyers for Boahene and his wife, led by Samuel Atachian, applied to the court for further disclosures to say that apart from the documents that had been supplied to them by the prosecution, there are certain other documents that they would need to make their defense. The High Court denied that plea. Based on that, they appealed, and also they came to the Court of Appeal arguing that the judge presiding over that matter has shown some form of bias and should be prohibited. And as part of the Supreme Court pronouncing on that application, the Supreme Court dismissed their application, asking for the judge to be prohibited from further considering the matter. But the Supreme Court went on further to make a pronouncement on what disclosures or what law should govern further disclosures. The judicial system uses what is called the practice direction from the Chief Justice, and in this practice direction, it is given that to justify further disclosures, the matters you are asking for must be in the possession of the prosecution, here that is the Aegis Department, and also must be relevant. The Supreme Court, in addressing the issues as brought to it by the accused person, that is Kwabena Boahene and his wife, indicated that the matter of relevance cannot be considered at pre-trial stage, and relevance relates to the probative value of a certain material fact and how it would yield the court in deciding a matter. And so if any court is deciding on the issue as far as further disclosures is concerned, it should be materials that are in the possession of the Attorney General's Department, that is the prosecution, which are material or in connection with the case at hand. The Office of the Attorney General, having reviewed the ruling of the Supreme Court, and according to the Deputy Attorney General, upon consultation with various stakeholders in the security and investigative space, they felt that that lower burden of, or their understanding was that the ruling of the court created a lower burden where accused persons and their lawyers will only have to show that a matter or a material is in possession of the prosecution for further disclosures to be allowed. In their view, that is not good for Ghana's criminal jurisprudence, and so they invoked the review jurisdiction of the Supreme Court, asking the Supreme Court to review its decision and restate in the practice direction that to prove or to make a case for further disclosures, then you need to prove that the materials are in the hands of the prosecution and also relevant. Atachian disagreed with them, noting that the burden to even invoke the review jurisdiction of the Supreme Court have not been met in this particular instance, and as a result of that, the case should be dismissed. The Supreme Court, upon listening to the parties, set January 14, 2026 to deliver its ruling on the matter.
Very well, Hansen. So did we see Boahene in court himself? Were his lawyers present in this matter? Atachian, was he there himself? And regarding this matter, then it will have no business to do with the initial accused person who is now going to be to testify for the prosecution.
No, it has nothing to do with Mildred Donko, the third accused person, who we are told has been charges have been dropped against and will be called as a prosecution witness. Boahene was in court. His wife, Angela, was also in court, as well as their lawyer, Atachian, who made arguments against the position as espoused by the Attorney General. After court proceedings, we spoke to Samuel Atachian, who says that the current ruling or decision of the court is good for our criminal jurisprudence, because then it prevents situations where prosecution would decide to present evidence that is only relevant to them and keep evidence that they deem not relevant to them. And he says that the court saying that any material that is connected to the case should be served on the accused person at the time of disclosures is good to help at least espouse and uphold the principle of presumption of innocence until proven guilty.
Well, Hansen, so this January 14 date, what implications does it have on the original case being prosecuted by the AG and the ruling that will come on the 14th? What will it mean for that same case?
Well, this is more a matter of enriching Ghana's constitutional jurisprudence and also setting a pathway for future cases. Mind you, the main case was actually won by the Attorney General. Atachia, that is lawyer for Edu Boahene, actually lost the application. But the Attorney General says, in respect of the criminal jurisprudence of Ghana, even though the Office of the Attorney General won the application at the Supreme Court, it's important that they apply for the review jurisdiction of the Supreme Court to partially review that aspect. So they are looking into the future. If the status quo remains, and on January 14, if the Supreme Court comes out to say that wrong with its decision and that remains the law, then what it means is that at the time of disclosures, where prosecution is giving out the materials and potential evidence to accused persons, then the only thing that should be considered is that are the materials in the possession of the prosecution, and are they in any way connected to the case? If they are indeed connected to the case and they are with the accused, they are with the prosecution, then there's a responsibility on the Attorney General or the prosecutor in the matter to give the documents to the accused person. However, if on January 14 the review bench of the Supreme Court decide to change the position as espoused by the ordinary bench, then perhaps they may decide to reinstate the issue of relevance, meaning that you would have to prove a threshold that the documents you are asking for are not only with prosecution but are also relevant to the case. The Attorney General's Department, represented by the Deputy Attorney General, argued also that even if it is not relevance, there should be some adjective or phrase that increases the threshold beyond just the material in the possession with the accused, with the prosecution, to something that would be of relevant fact or of relevance to the case in question. And he argues that at this point there should be a distinction between relevance in the technical sense and relevance in the ordinary sense.
Beryl Hansen, thank you so much, and we look forward to updates and subsequent reports that you'll be filing in our subsequent bulletins here on Channel 1 Television. Hansen Ajiman is our court correspondent, bringing us up to speed regarding two separate cases, one involving NAM1’s, also known as NAM1, and a review application he sought at the Supreme Court, which application we understand has been quashed, and so the High Court case can continue. The second one had to do with also a review application by the former Signals Bureau boss, Kwabena Edu Boahene. We understand ruling will be given on January the 14th. And so we await to see the outcome of that. So, Chris, yeah, forgive me for invading your space, but this is the news I came with.
Yeah, luckily we were already done with what we were doing, but thank you. It was really nice, for you to come and share.
PENDREAM TV. Now, so far so good. Say open online portal e Ghana. Nipa share, nipa follow, nipa comment here. To my best of knowledge, without any biases, PENDREAM TV.